Good afternoon. Welcome to the Appellate Division First Department. We have about 6 hours of argument time requested, so only ask for the time that you need, not the time you wish. If we have further questions, we will keep asking them. The first case is People versus Berry, submitted. Pacquiao versus Georgetown, appellant. Pacheco. Are you the only one here?
I'm a respondent from Dewey Electric.
And is the cross appellant here?
It wasn't a cross appellant, it's two respondents here.
I'm sorry, the other respondent here? Okay, so who's the appellant? And how much time are you requesting?
5-2.
And how much? 5, 1, and 5. Regla versus Dustin is submitted. Estrella versus Ganley, appellant.
Defendant appellant requests 5 and 2, Your Honor.
Respondent?
5 minutes, Your
5,
Honor.
2, and 5. Peralta versus Hunter Roberts Construction, appellant.
Appellant requests 5 and 2, please, Your Honor.
Respondent?
Appellant respondent requests 5 and 2, Your Honor.
5, 2, 5, 2, and 5. People versus Lafreme is submitted. Cortez versus Complone.
Thank you, Your Honor. 5 and 2.
Is anyone else here on that? Do you wish to submit it?
Sure, that's fine.
Okay, it's submitted. Ramos versus City of New York, appellant.
Defendant appellant requests 5 and 2, please.
Respondent?
Respondent plaintiff, 4 minutes.
5, 2, and 4. Gian Grande versus Gracie Gardens, appellant.
Appellant requests 5 and 2.
Respondent? 5, 1, and 5. Funty versus Andrews, appellant.
8 and 3, Your Honor.
Respondent?
Stand up, please.
6, 1, and 6, and if we have more questions, we'll keep asking. Capitis Servicing versus Ragtime Gourmet, appellant.
5 and 2, Your Honor.
Respondent?
5, Your Honor.
5, 1, and 5. 382 McDonald versus NYC Industrial, appellant. Appellant?
Your Honor, 6 and 3, please.
Respondent? The other respondent?
Respondent 302 Meat Corp and 302 306 Church Realty Corp request 5.
Okay, I'm going to make it 5, 1, 5, and 5. Lovett versus 2600 7th Avenue, appellant. How much time are you requesting? 15. And do you want rebuttal time? It's okay. Respondent?
5.
Okay, 5, 1, and 5, which means you'll have 5 minutes for your main argument, and then you'll have a minute for rebuttal when the case gets called. People versus G is submitted. Pritchett versus American Golf is submitted, and Claris versus 600 West 183rd is submitted. So our first case is Georgetown 11th.
Good afternoon, Your Honors. Douglas Miller for Caldwell Wingate Appellant. This comes as a 3211.
If you could just speak up a little bit.
This comes to the court as a pre-answer motion to dismiss on 3211. I have the employer in a labor law action. We're in sort of a strange procedural posture. We were already a third-party defendant from Dooley, solely on common law claims claiming grave injury, as we were the employer, and Dooley didn't have a contract with us. That's 7 years in. The owner, Georgetown Electric, the direct defendant, or the first direct defendant, and the other respondent brought forth a third-party complaint. We moved to dismiss on a variety of grounds. none of the respondents addressed the rationale of the court below, but it was dismissed without prejudice, in part because I guess we raised the grave injury issue, and the court noted that first, the motion court didn't think the plaintiff was a party to the action, and then noted the plaintiff didn't put in papers, and the concern was adjudicating injury claims without the plaintiff. Our position is he was a party.
Let's put aside the issue that plaintiff has not opposed the motion. And let's separately address each of the motions. The two of the primary issues were the grave injury and the anti-subrogation. So do you want to address, why don't you start with the anti-subrogation and why?
Okay, so anti-subrogation, pretty straightforward.
Well, let me ask you a specific question about that, the anti-subrogation. Why isn't it too early? And I understand that there is a company, an insurance company that's representing them right now, but there is a risk that at some point they're going to bring a declaratory judgment action and argue there's no coverage. So why wouldn't we wait to make any ruling on the indemnification until that is determined?
So the case law where they consider it premature, you get what I would call a standard ROR, a reservation of rights letter. You tender the claim to the carrier says, there's some issues here, but we'll pick up the defense because they do duty to defend.
Isn't the real heart of those cases the issue that it's still not determined? I mean, the anti-subrogation rule only comes into play if there's actually coverage by this insurance company of the two entities. And we don't know that till a final determination is made one way or another. And since the possibility still exists that insurance company will not be providing coverage, why shouldn't we wait? Why shouldn't the court wait to make a determination?
I mean, two reasons. One, both letters in the record say Zurich picked up for defense and indemnity, and it says we now think there might be reasons to bring that declaratory judgment action, but we haven't brought it yet. So unlike most cases where it's a reservation of rights and defense only, in this instance, we know they picked up for indemnity, and according to Zurich...
What's the harm in waiting? Because the indemnification is not going to come into play until there's ultimately a finding of liability in the case anyway, and the statute of limitations wouldn't be running on it. So why make a determination now when that issue is still out there hanging over the case?
And that's the second part of the argument. Based on Zurich's claims, they have to go to court. They have to get a court order saying you can disclaim, and the basis for that...
They could do that.
And the basis would be it doesn't arise out of our work. That's what they're saying. Now, if they get that court order, Georgetown's a part of that case. What do they need to get contractual indemnity from?
I couldn't find any case that bit on that argument. I thought it was a creative argument and interesting, but I didn't find one case that sort of supported that we should be that far-reaching in our analysis, because who knows what could happen. If and when a declaratory judgment action is brought, how do we know what the court's going to decide? They may decide there's partial coverage, but they could decide anything. So why jump the gun and make a summary determination on indemnification now?
Really admit there's no court case that says that, but I think we're in a materially different situation than you typically have. Right now, Zurich could pull my client's coverage for some ground we don't know about. Failure to cooperate, fraud in the procurement. That risk always exists. This is not a typical case where there's a pickup for the additional insured with a reservation of rights. It's a pickup on defense and indemnity, and it's only later that they start talking, well, maybe we'll bring this coverage action, and they still haven't brought it.
Let me ask you a quick question about the grave injury. Why shouldn't we wait? Because plaintiffs still could present an expert report in this case that does raise an issue of fact as to grave injury, and discovery is not complete. So why isn't it? I know that defendants don't really have any interest in finding a grave injury because they're defendants. It would be the plaintiff who would bring forth some issue. So why should we make any determination yet about grave injury before plaintiff has run out of time to present their expert report?
Well, one, the note of issue was filed in between the motion and now, so discovery is technically closed. We're doing some post-note discovery.
Right, but we don't have that information on this record.
If I'm Dooley or Georgetown, what am I going to do when I see those reports that say he doesn't have a TBI and he's not disabled? I have the medical records. They say, well, plaintiff's physicians could testify. Great. You know how you prove that? You show the medical records where plaintiff's neuropsych says he's so horribly, injured. And they don't have that, and they didn't put it in, and the doctors that looked at his records, which you have, all say there's no indication of a traumatic brain injury, and they all say there's no indication of a neuropsychological or neurological disability.
Thank you.
Thank you.
Oh, I'm sorry, do you want to?
I just want to ask one question. What's to stop the plaintiff 30 days before trial from serving a 3101D notice? Here's my expert. He says I have a grave injury. Nothing.
But the
Right?
issue with...
That hasn't happened yet. And we can't, so, and it may very well happen. In fact, it happens a lot, right?
But the implication of that is I can never move for summary judgment on the claim. And
Oh,
yet-
you absolutely can, after the plaintiff does, after the plaintiff serves a 3101D motion, right? Or
But if I do that 30
disclosure.
days before trial, I'm out of time, and this court has, on a 3212 motion, on expert reports, even with medical records, said, well, if the experts say X, and just
So then what happens if the jury finds there's a grave injury?
the issue wouldn't get presented to the jury.
Oh,
'cause
sure it will. The plaintiff's going to put it in.
The plaintiff's not going to say I have a grave injury. The plaintiff's going to say I have a traumatic brain injury, I have a cervical herniation with, fixation, I have a lumbar injury with fixation, I broke my hand, I, tore my knee. He's going to say all that stuff. And when the jury says he's disabled, they're going to ask a questionnaire? No, right? That only comes in if.
I don't agree with that. I think that that would absolutely could be a question asked. So it could be, that's the problem, is that it's premature, right?
It'd be premature in any case where summary judgment's granted on the grave injury, and yet we cite a number of cases that did it on expert reports.
Thank you.
Good afternoon, Your Honors. Chris Hart for Dooley. I probably overzealously reserved 5 minutes. Georgetown is the main respondent here. They haven't appeared, so I just feel compelled to touch on the anti-subrogation issue. I think the bench asked all the right questions there. In my view, and I think it's said succinctly in our brief, you can't be half pregnant. There's different ramifications if you reserve your rights. The carrier doesn't get to control the defense. There's different outcomes that could potentially occur here. And the mere writings to their potential insured indicating that they may change their coverage opinion, we believe would be sufficient to keep that claim in. Moving to the grave injury issue, I think, and counsel alluded to it himself, there's a distinction between a 3211 motion and a 3212 summary judgment motion, and we're simply not there yet. That day may come, but it's not today, unless the court has any further questions.
Thank you.
Thank you.
Just briefly, 2 quick points. I noted, but I just want to emphasize, there's always a risk of that DJ being brought when someone has coverage, which would render any defense under anti-subrogation always premature till after trial, and I think we know that's not typically how it works in litigation. And then just on the motion, the burden I have is I'm here on grave injury, I'm here on 3211A1. And if I put a document before the court, the question is, does that fully dispute negate the element of the claim? We say it does. We know what the elements of acquired injury to brain are under Section 11. There's nothing that anybody introduced in this record after 7 years of discovery that would question that.
Thank you.
Thank you.
Estrella versus Ganley.
Good afternoon, Your Honors. May it please the court, Jack Lockwood for the defendant appellant. This is a secured transaction, Your Honors, that's uncontested. The complaint in this action did not allege or disclose the existence of the collateral that secured the underlying loan. The affidavit of merit that was used to secure the default judgment against the defendant also did not disclose the existence of any collateral that was used to secure the loan. However, it's undisputed on this record that Mr. Ganley pledged 235,779 shares of Rivada stock. If you look at the loan agreements, it actually gives the lender, which was Worth Capital, the right to convert the debt into those shares at a certain purchase price. That purchase price was over $400 a share. After Mr. Ganley defaulted in the repayment of the loan.
So may I interrupt you, counsel? We're talking about a contempt order, right?
Excuse me?
We're talking about a contempt order?
Right now, Your Honor, I was talking about appeal number 3, which is defendant's motion for a satisfaction or a hearing on a partial satisfaction of the judgment, Your Honor.
Okay, and what did you put in to show that the judgment was satisfied?
Your Honor, the record indisputably shows, as I was going through, that this loan was secured by collateral. The collateral was allegedly foreclosed on. It was not purchased at the call right price, which is set forth in the agreement. It was
Did you seek a
purchased.
partial satisfaction from the lower court?
Excuse me?
Did you seek partial satisfaction from the lower court?
Yes, Your Honor. I think that he moved for a full satisfaction, but in the alternative, he asked for a hearing as to the market value of the assets that have already been turned over, and including the collateral that was used to secure this loan, which it is undisputed plaintiff's predecessors and interests continue
One
to
second,
retain.
I just want to interrupt you. You sought a declaration that the judgment was satisfied, right? You didn't ask for a partial satisfaction or something else. You sought a declaration that the judgment was satisfied.
Your Honor, he moved for a declaration
That the judgment was satisfied.
and the
That's
case
a-
law, which we cited, shows, and in the alternative, he asked for a hearing, Your Honor. I think that in the event that he failed to show that the judgment was entirely satisfied, the case law shows, and we cited, that he is entitled at least to a partial satisfaction piece. It's the
But you
same
didn't ask,
statute.
again, counsel, my colleague asked you, did he ask for a partial satisfaction? Is there anything in that motion that says, I would like a partial satisfaction?
He said, I would like a hearing.
A
in the
hearing, which
event.
is not because you're saying that the reason to have a hearing would be there's a disputed fact issue on whether or not your request for relief, which was full satisfaction of the judgment, whether there was a factual issue as to that. Not a hearing on other, you just didn't ask for it. You asked for a hearing on your motion for a full satisfaction of the judgment.
Your Honor, he cited the statute. He asked in the alternative, as I said, for a hearing on it.
On his motion for full satisfaction.
was
And the
not
only reason
entitled-
why, one second, let me just say, the only
ma'am.
reason why we would have a hearing is there was a disputed factual issue. What disputed factual issue is there on whether or not he fully satisfied the judgment?
The market value of the collateral was more than enough to satisfy the entire judgment, Your Honor. They allegedly sold it at a Texas auction for 42 cents a share. The loan agreement set a call right price at over $400 a share. About a little more than a year later, they turned around and sold less than half of those shares for over $5.8 million.
And what did you put in to show, what documents did you put in, other than the documents, the loan documents, to show that that was not a good price? You put in an expert opinion?
We did not put in an expert opinion. As my
put in-
adversary pointed out, he's got a restraining notice on all of his assets. He does not have any money to hire an expert. The loan agreement itself sets a price, a call right price. They turned around and sold it. This is all undisputed for $5.8 million about a year after they bought it for 42 cents per share. In addition, Mr. Schuman purchased 3,700 shares at $2.5 million in 2016. That's $668 a share. In addition, he put in evidence of more recent values of accredited private investors who have purchased at $755 a share. That's at $341, $913, $931, and $940 in the record, Your Honor. This is sufficient to raise a triable issue of fact as to whether the judgment is entirely satisfied.
Thank you. You'll have further time on rebuttal.
Thank you, Your Honor.
May it please the court, Richard Schoenstein for respondent. I have a
Counsel, is there an issue of fact as to whether the judgment has been entirely satisfied?
zero issue of fact, Your Honor. Justice Schechter said, give us an appraisal. Give us an expert opinion. Nothing in the voluminous record, not once is there any sort of appraisal, any sort of evaluation of the value of the stock, any expert testimony. The only thing there is they say, well, sometimes the stock sold for different prices to different people. That's not evidence that the stock was worth more.
And what was put in to show that, like a ticker?
No, just testimony, just Mr. Ganley's affidavit about sale prices at different times. The stock that was foreclosed, first of all,
The defendant's testimony that this
Yes.
stock sold this day at this price,
correct.
that's what was put in?
Woefully inaccurate.
Let me ask you this, was there any question raised as to whether or not the sale of the shares was commercially unreasonable?
No. The shares were sold. There are two public auctions. The first public auction, about 250,000 shares, which were foreclosed before this lawsuit was even brought, were sold for $100,000. There's no evidence that Mr. Ganley or Rivada even put in a competing bid. And by the way, that issue is foreclosed. This court has already heard and affirmed the default judgment in this case. Any attack on the complaint or what happened to the stock before the complaint should have been raised when this case was filed. It wasn't. There was a default. They came up to this court. They lost. That is gone. There's one more sale of Rivada stock. We got our hands on 20,000 shares. We went to public auction. We credit bid. My client Estrella credit bid $400,000. Their client didn't even meet that bid. We outbid them at a public auction. Rivada, it's Rivada stock, wouldn't bid over $340,000 for the stock. So they can put in a self-serving affidavit they want, but when it was time to put their money where their mouth was, they thought the stock was worth even less than we thought it was. There's not a shred of evidence that would support an evidentiary hearing. And Justice Schechter, who has been very measured throughout these proceedings, she's given us a lot of relief as we've tried to enforce this judgment, but she has twice denied our application for a full-scale asset freeze. She said—
Well, because she doesn't have, I mean,
I
even though
appreciate it.
the first contempt order, I mean, it encompasses a lot of things. She doesn't have jurisdiction over the property in Ireland, right? But but it's partially enforceable because there are plenty of other things she required the defendant to submit, right? So you're asking for her to get you the property in Ireland. She can't do it. You know she can't do it.
She can enforce, she can jurisdiction over the person.
Doesn't
who owns
matter.
the
She
property.
cannot issue an order that would affect that property.
So that matter, Your Honor, was eventually settled by a stipulation in order that the parties agreed to and the court entered, and so that's over, and you don't get to reverse that.
But there is, I mean, look, she said, turn over the money. That's perfectly, if you have jurisdiction, you can tell somebody, turn over the money, turn over the cars. You can say that. That's all personal property, right?
That's right.
That's not a problem.
That's right.
So, I mean,
3 contempt orders, not a shred of evidence that they satisfied, and as Your Honor pointed out, never put in for satisfaction of judgment or partial satisfaction. They requested a hearing. The judge said, show me the evidence you want to put on at hearing, and there were crickets.
Thank you.
Thank you.
Your Honors, first of all, I'd just like to say it's more than Mr. Ganley's affidavit to establish that these prices were not commercially reasonable. On their face, 42 cents a share is not a commercially reasonable disposition. That is a non-waivable duty of the lender.
what do you mean on its face? Why not? Why on its face? There are stocks that go on public on the day of the public offering for a lot of money, and then 6 months later drop to 35 cents. What does that mean on its face?
On its face, I mean on the record, which—
No, is there an expert that says that on its face that stock could never have sold for that price?
I think it's a reasonable inference on this record based on the call purchase price of the loan agreement for over $400, and then a little more than a year later, they turn around and sell less than half of it for $5.8 million. I think that's sufficient to raise a triable issue of fact on its face, Your Honor. 42 cents is an anomaly on this record. There's nothing even close to that. The record demonstrates that this collateral was not worth $0. However, this complaint, this default judgment, is in the full principal amount of the loan. It's undisputed that this is a double recovery. The predecessors in interest have retained all the benefit of the collateral. They continue to retain that benefit. They've never disclosed to the court what they did with it, They've never had to account for it at all. This is properly raised, this issue is properly raised in defendant's motion for a satisfaction of the judgment, and I continue to argue that your honors have the discretion to view that as also a request for a partial satisfaction. It's the same statute, there's no prejudice at all, and it allows you to reach the issue regardless of whether it's a full satisfaction. He's entitled to know how much he's paid, how much the collateral offsets the judgment,
Thank you.
and how much is left. Thank you, your honors.
Thank you very much. Peralta versus Hunter Roberts.
Good afternoon, Your Honors. Anthony DiStefano for Plaintiff Appellant. As I understand it, defendant's argument is that they fulfilled their absolute duty under the labor law to construct and place adequate safety devices by giving my client and his coworker a pile of wood and instructions to build their own temporary wooden scaffold. Since this court and the Court of Appeals have both held that that impermissibly shifts the responsibility from the owner and the GC to the worker to provide for their own safety in violation of the labor law, we believe that the order appealed from should be modified to
Why
grant.
isn't there an issue of fact as to whether the worker was the sole proximate cause based on the testimony about that he was repeatedly told not to build a scaffold that way? He didn't go and get it inspected, where the supervisor claims he was requested to have a final inspection before you use it. Why isn't that enough to create an issue of fact as to sole proximate cause?
Because again, Your Honor, as I said, and this court and the Court of Appeals are in agreement on this, this court's decision is Collins, where they were given wood and told to build their own safety device, and Batista, where it was specifically a wooden plank that the plaintiff was told you should only use pine planks and you should make sure that there are no planks with knots in them. You should use those devices, and when the plaintiff arguably didn't do that, the Court of Appeals said that that was not enough to create a question of fact on the issue of sole proximate cause. So it's the burden of the owner and the GC in the first instance to construct and place these devices, not to give the workers instructions on how to build their own. Again, we're not even talking here about a baker scaffold where it needs to be assembled. We're talking about literally constructing a temporary wooden scaffold. So, and my client and his coworker both confirmed that baker scaffolds were not even made available to them at this job site, even though there were other trades on the site that did have baker scaffolds. So for that reason, my client, at most, for the manner and way that he built the scaffold, and he built it in conjunction with a coworker, by the way, so we can't even say that my client is solely to blame for this because the coworker was there helping him, and we don't know who chose the wood that goes into the scaffold. And under the Court of Appeals decision in Barretto, where there are two workers involved in whatever the operation is, you can't have one be the sole proximate cause of their accident, absent some proof that it was only their fault, which we don't have here.
So is it your argument that the owner should not have asked them to build the scaffolds, and that caused the violation?
Correct, Your Honor. It's the owner's responsibility in the first instance to construct, a place, and operate. That's what the law very clearly says, right in the statute.
You can't
In this
pass
case, the
that.
owner didn't do that. And in this case, the owner didn't do that.
They did
Provide
nothing
an
but give a
adequate
pile of wood. Correct, Your Honor.
safety. Okay, thank you.
Thank you.
Good afternoon, Your Honors. This case is distinguishable from the cases that the plaintiff is relying.
Why don't you address Batista first, because Batista does seem to be remarkably similar
This
in
case
terms of the facts. So how do you distinguish Batista?
This case goes so much further than Batista. Batista, the plaintiff, used the improper wood for the job. That was basically the issue in that case, was that he used improper wood to build that scaffold. Here, you have a plaintiff who has he's a 30-year veteran in the construction.
You can always find factual differences, but why isn't the fundamental reasoning of Batista that it's the owner's duty or the contractor's duty to provide the adequate safety device, and you basically can't pass that duty on to the worker, and if there's not an adequate safety device, then there's a viable 240 claim. What is wrong with that argument?
Because here, the custom and practice for the work that they were building, which was building these trusses, was to construct their own their own scaffolds and their own, because
What do you mean the
even if it
custom and
was the custom-
practice?
Go
Yeah,
ahead.
I'm sorry. What does that even mean, custom and practice? You
the,
mean that that's required, everybody, at every job site, everybody's building their own scaffolds?
well, these workers, because of the work they were doing and because of
Well, that's what I'm trying to figure out. Are you saying just because, like, that's the way it's always done, that's your defense?
that's the way this work is done, is that, is
But
that my understanding?
How
I'm
does
sorry?
how does that relieve you of your obligation to do it? Because you said, well, we've passed it on before, we're going to continue to pass it on. That can't be right.
Well, because he was provided with instructions on how to build the scaffold.
All right, but the problem with this argument is the law is pretty clear in these 240 cases that it's the duty of the owner, the general contractor, to provide an adequate safety device. And you're basically arguing they can pass on that duty to the worker, but the labor law cases don't really seem to support that type of argument, that you can basically pass that duty on and therefore say the owner and contractor are not responsible for providing an adequate safety device because they told the worker to provide the adequate safety device. I mean, that's the basic argument. So how do you get around that, I guess is the question.
Because based on the facts, because, I mean, everything's fact-specific. So, I mean, this case is different from, you know, some of the other cases where the owner was responsible for providing the scaffold.
But is an owner allowed to pass on its responsibility to provide an adequate safety device of the labor law? That's the fundamental question. Can it pass that obligation on to the worker and say, well, yes, we have a duty to provide adequate safety devices, but we're going to pass on that duty to you, the person who's doing the work?
I mean, I wouldn't say that the duty was necessarily passed on to the worker because he was aware of how to build these scaffolds correctly.
The cases where you have sole proximate cause or recalcitrant worker, those are cases where there was an adequate safety device provided, and for some reason the worker refused to use the device that was provided to him. But your argument doesn't really fit into that mold because there's no argument that there was an adequate safety device and he didn't use it. You're saying he didn't build the device right, which doesn't really fit into the providing of an adequate safety device.
Well, the materials, I mean, he was instructed on how to construct this device correctly. He was constructed.
But that's,
on what
again, no,
technology
it's your responsibility as the owner to make sure that it's proper, right? Not his, yours. So how have you discharged that responsibility?
just by making sure that he had proper instructions on how to construct the
Okay.
scaffold.
Thank you.
I have other issues if.
Yeah, you have 30 seconds left, so if you want to argue something else, go ahead.
Okay, just that we're also entitled to contractual indemnity from.
I'm sorry, what?
We're also entitled to contractual indemnity from Golden Eagle because the indemnification provision in the
And you're asking for conditional, right? So in the event that the excess doesn't get to come to play, you're asking for conditional based on the indemnification provision.
Yes, because it's a broad arising out of trigger.
Okay, thank you.
Good afternoon. With respect to the issue on indemnification, the owner GC's claims are barred by the
So maybe you could
Sorry,
bring down the
I'm
microphone. so we
short.
can hear you better.
The owner GC's claims are barred by the anti-subrogation rule. My clients.
Let me ask you something, because you argued the anti-subrogation rule, but it has to be the same insurance company. And the situation we're talking about here is basically the middle layer where it's not the same insurance company. If the indemnification was for the first layer, that would sound right because it is the same insurance company. But since the excess insurer for Golden Eagle is taking the position that it doesn't have to provide coverage because the policy didn't have the right language about primary and non-contributory, isn't there a strong argument that the anti-subrogation rule wouldn't come into play as to the excess insurer because they're not providing coverage for that layer.
Understandable. However, our argument with respect to the the claims with respect to excess is premature. There has been no settlement, no adjudication as to whether or not any judgment will reach the excess layer. There is
Then
a
that's the
primary-
whole idea,
Oh, I'm
isn't
sorry.
that the whole idea of a conditional indemnification, which is, I think, what they're requesting. And they're not requesting an absolute indemnification because it might never, you're right, it might never come into play. They're saying if it comes into play, they are entitled to a ruling that there should be indemnification. So why shouldn't the court grant that?
Well, one, with respect to the excess coverage, there's no allegation that there is no coverage. There's an allegation as to whether or not it's a priority of coverage, whether or not the other insurance clause is going to come into play in the absence of the primary non-contributory language. That is for a declaratory coverage action. That's not for the purpose of indemnification. For the purposes of indemnification,
Aren't you
we've
allowed to
already
seek-
picked up without reservation.
Aren't you
both-
allowed to
oh, I'm
seek
sorry.
indemnification for any amount of liability for which there's potentially not coverage? And the excess insurer, even though it's undisputed that the contract provided that Golden Eagle's excess insurer should come into play before the other insurance, they're taking the position based on the policy that was obtained that they're not going to come into play. So why shouldn't there be indemnification as to that layer?
I think parsing through that, my client's obligation was to purchase the insurance. The insurance is available. How the carrier determines how to interpret the policy, that is not a contractual indemnification argument. That is a coverage argument, and the plaintiff's case.
You're making an anti-subrogation argument. The only reason you're arguing that indemnification should not come into play is because of anti-subrogation, and to determine whether or not anti-subrogation comes into play, we have to look at the policies, because that's how anti-subrogation works.
I understand. With respect to anti-subrogation, I don't think the issue is whether or not it's simply and whether or not anti-subrogation rule comes in play. There were two arguments. I'm so used to plaintiff being my adversary. Third-party defendant, their claim is based on, is with respect first to anti-subrogation. And that portion of the case is properly determined in that there are the primary policies for my client, Golden Eagle, has accepted their client as an additional insured. Both their client and my client are additional insureds on the policy. They're to be treated equally.
Right, and they're not seeking indemnification as to the first layer.
So are they withdrawing their argument is twofold. Are they withdrawing their claims as to indemnification with respect to the primary policies, and only having the argument with respect to whether or not a conditional order should be
That was
issued?
my understanding of their argument, that they're not seeking indemnification as to the first layer, because, I mean, they could clarify, I guess, in their rebuttal time, but that was my understanding.
That was,
Find out on their rebuttal time.
do I have time? Am I finished? I think my time.
You have time, if you have 20 seconds if you want to argue anything else.
No, I'll rest. I'll
Okay.
leave the 20 seconds on the table.
Thank you.
Unless the court has any questions for me, I don't need to take up any more of the court's time this afternoon.
Thank you.
Thank you.
Why don't you clarify that very question? Are you only seeking indemnification as to an amount over the primary?
Yes, I believe
Coverage.
that's what we are arguing in our paper. Whatever, yeah, we're seeking indemnification up to the amount permitted by law here, which would
You're not seeking indemnification for the first policy, because there's no dispute that they're providing coverage as to that first layer. Is that correct?
right. Yeah, they have picked up coverage on a primary and non-contributory basis for our clients.
And there would be a problem with anti-subrogation if you were trying to,
Yes,
yes, okay, so you're
Only
only,
excess.
Right.
You're only seeking indemnification as to the amount over and above the primary policy.
right. It's that the white case that we rely on in our papers, where our carrier is which is Lloyd's, is in the same position as the owner's carrier in the White case. And the court found that their claim against the plaintiff's employer's excess wasn't barred by the anti-subrogation doctrine. So, I mean, we're in an identical position in this case.
Okay, thank you.
Thank you.
The next case is Ramos versus City of New York.
Good afternoon, and may it please the court. James Wise for defendant appellants. This is a personal injury action brought under the Child Victims Act. We are seeking reversal of the lower court's decision preserving plaintiff's premises liability claim as it is duplicative of her claim for negligent hiring, retention, and supervision. This is because both causes of action arise from the same predicate allegation, which is that there was an alleged abuser whom appellants negligently hired, retained, and supervised, and who knew or should have known that he either abused the plaintiff or it was reasonably foreseeable that he would abuse the plaintiff. In addition, both causes of action arise from the same alleged breach of a duty owed to plaintiff to keep her safe from foreseeable harms perpetrated by third parties. Further, both causes of actions seek the same damages and allege the same injuries. This position has been supported by the Second and Third Department in Stephen B. v. Westchester Day School, Fay v. Troy City School District, and a multitude of other CVA cases. Finally, I would like to briefly note that it is our position that the court misrelied on the holding of Kathleen Reno v. Churchill Chili's Central School District, because in that matter, the plaintiff's
You
premises...
also addressed the issue in Noel, right? The First Department.
Correct,
That
yes.
was the
no
same
one was wrong.
issue that was addressed by us, which supports your argument.
Correct, yes. In regards to the Reno decision, in that matter, the plaintiff plaintiff's premises liability claim was her only avenue of recovery for an alleged breach of a duty to protect her from foreseeable harm. The court of Reno did not address a situation where a plaintiff brings a multitude of causes of actions seeking for remedy under that same theory. Whereas, as Your Honor mentioned, the court in Noel, the court in Stephen B., and the court in Fay all have, and they have all found that these causes are duplicative, and accordingly it's our request that the lower court's decision be reversed and plaintiff's claim for premises liability be dismissed. That's all I have, absent any questions. Thank you.
Thank you.
May it please the court, Niraj Parekh of Slater, and Schulman on behalf of respondent plaintiff Diana
Counsel, why
Ramos.
shouldn't we follow our prior decision in Noel, which addressed this very issue?
Well, the Noel case was decided on summary judgment. This is
Decided, I'm sorry, what?
that case was determined on summary judgment on a full record. This case was brought by these defendants on a motion to dismiss under
Isn't it a
CPLR
purely
3211.
legal issue whether or not the causes of action are duplicative based on arising out of the same duty, which is a duty to know about the propensity of the employee? So since the legal theory is exactly the same, what does it matter what the procedural posture is of the case?
The legal theories are actually very distinct. Under the negligence causes of action, you are correct that there is
They're not seeking to
requirement of
dismiss the negligence,
propensity.
though, right?
If they're not.
They're only seeking to dismiss the premises.
And only on the grounds that it is duplicative, not on the grounds it is not sufficiently
Right,
stated.
no, they're seeking that it's duplicative of the,
So for the negligence claims, you would, while they arise out of the same facts and circumstances, you would still need to establish and prove the propensity issue. That is not an element of the premises liability claim. And the Honorable Sabrina Kraus in the
you'd have to
court
show
below-
that they were aware that there was, premises liability does require that the owner of the premises is aware of a danger, and the only way you would be able to show that an owner of a premise is aware of a danger is if they knew that there was some propensity on the part of the employee to engage in this type of behavior. Otherwise, they wouldn't be aware, and it wouldn't give rise to a premises liability.
It is a different set of awareness for the propensity.
In what way? It's, in what way? What's different?
Vicarious liability is initial. my
No,
initial
no, no,
response,
you're
because
saying factually. I want to know factually,
as
what
the
is
owner- as
different
the
about,
owner
one
of the-
second, let me just finish the question, okay? Then because I do want to hear your answer. What's factually different about knowing propensity for the purposes of a negligent hiring and retention claim as opposed to knowing propensity for a premises liability?
So for premises liability, they are in charge and responsible for maintaining the premises in a safe manner. They can be held liable directly as well as vicariously. That does not extend to the negligence causes of action. And there is a world where those claims can be distinct. And this court in Brown versus Riverside Church, 231 AD 3rd 104, decided in July of 2024, specifically said that the notion that a plaintiff cannot plead multiple causes of action premised on the same underlying facts and circumstances is inconsistent with CPLR 3014's invitation to plead in the alternative. And just two other points, Your Honor. They've not made any argument that the premises liability is not sufficiently pled, and the purpose of a 3211A7 motion, which they made, is to allow properly pled causes of action to prevail. Finally, there is no litigation efficiency to be gained. They have argued up and down that these are the same facts and circumstances, so there is no prejudice to the defendant in allowing this claim to be pursued. By contrast, there is severe prejudice to the plaintiff if the claim were to be dismissed at this early stage on no discovery and without a full
Also,
record.
you're alleging that the perpetrator here of the sex abuse was either an agent or an employee of defendant, correct?
There are multiple defendants here, but yes, that is what we are alleging.
Thank you.
Thank you.
Just quickly address that the purported availability of vicarious liability does not create a new distinct theory of recoverability for the plaintiff.
I recall many cases where we have dismissed duplicative cases on, duplicative causes of action on a motion to dismiss, right?
Correct.
It's not the odd, weird case that we do that.
It is not, no.
Counsel is duplicative because it's the same facts, requires the same elements, and is seeking the same relief.
It is, and both causes of action are doing just that. They're based on the same facts as I previously articulated, and they are seeking the same damages. I believe that speaks for itself, and I'll waive the rest of my time. Thank you.
Thank you very much. Giangrande versus Gracie Gardens.
Good afternoon, Your Honors. May it please the Court, Edward G. Bailey for the plaintiff appellant Angelo Giangrande. Mr. Giangrande received a piece of mail in late 2022 and opened it and found a notice of sale, a private sale, a non-judicial sale purported to take place less than 30 days later by the cooperative court.
Counsel, we're familiar with the facts. There's really just one central issue here, which is whether or not the action in Supreme Court constituted a collateral attack on a judgment of possession issued by the civil court, which is not to say that it could or could not be litigated in civil court or housing court. The only question is where you get to litigate this issue, whether you get to litigate it in housing part or whether you get to litigate in Supreme Court. So why don't you address the primary issue and why it's not a collateral attack that we should dismiss on that ground?
Thank you, Justice Karn. That's why I tried to emphasize at the outset the non-judicial nature of the notice of sale, which is at 104 of the record. By virtue of a default in a proprietary lease, by and between the co-op, et cetera, will purport to auction off the shares and lease. It's not pursuant to a judgment of the civil court. Remember, in order to recover a co-op apartment, you have to recover possession.
Well, let's just go back a step. How can the Supreme Court determine the issues raised in this litigation without revisiting what's already been decided by the housing court in that proceeding?
Staying on that point, which I'm really trying to parse, the declaration of default contained within the notice of sale needs to be probed in discovery. What was the basis of that default? Now, certainly we have a very good idea of what that basis is going to turn out to be by looking at the civil court proceedings, right? And there, when we took pains to illustrate at length in our brief what the co-op went through in order to gain that judgment of possession. And the court below, quite properly, was sensitive to that issue. You know, you have possession at stake because by the time they got in front of the motion court, they had discovered what had gone on in civil court, and it had actually proceeded to a judgment on default some 6 years earlier.
So one second, may I just interrupt you for a second? You are seeking a declaratory judgment that the judgment of possession and warrant of eviction were void. That's what you're seeking here, correct? I'm literally reading.
Respectfully, that was withdrawn in our brief.
You can't withdraw it in your brief. You have to, that's not the.
That would be a collateral attack. So we did not appeal from those portions of the order below insofar as that cause of action as well as the
Here's
fifth
one,
cause of action.
the declaratory judgment that he was not in breach of the lease when you commenced the housing court proceeding. That's also what you sought. You're saying you withdrew that?
It would not, that would be a collateral attack, I'll concede. That would be a collateral attack.
How did you withdraw it?
The motion was withdrawn because by that time, when this motion was heard in Supreme Court, relief had been gained in civil court.
So what are you,
That became moot. It was actually withdrawn. The request for injunctive and declaratory relief was withdrawn on the record.
after this court issued its order, correct?
Prior to.
You withdrew these claims before the judge in this case, before the judge ruled on the motion?
The motion for preliminary injunctive relief, which is keyed to that declaratory judgment paragraph, as well as the injunction relief sought in the complaint, was withdrawn. The motion for the preliminary injunction was withdrawn. The claims for money damages, we are arguing here, should have continued.
Money damages for what?
I would say first and foremost, declaring Mr. Giangrande in default and trying to sell his
Okay,
shares
so
at
again,
private.
if you're asking for a declaration that he wasn't in default when they went to the housing court to get that relief because of that default, then you are attacking the judgment in housing court. I don't know how you can get away.
Not to say that.
I know
The
you.
notice of sale
But
had
just
nothing to do with housing court. That's what I'm trying to say. This was a non-judicial sale. The co-op was going to sell his ownership
because
at
he
private
because
auction.
he had a warrant of because they evicted him, correct?
I would disagree with that
All right.
respectfully, Your Honor.
Okay.
They had possession of the apartment by virtue of that. And
Thank you.
We are suing. Thank you.
Good afternoon, Your Honor. Kelly Ringston for the defendant respondents, Gracie Gordons. I am not going to need 5 minutes unless Your Honors have specific
I
questions.
just want to ask, do you agree that all these claims that are based on the housing court judgment of and warrant of eviction have been withdrawn?
No, of course not. They're part of the main action. The portion that there was a pending motion for preliminary injunction based on their first cause of action for declaratory judgment to stay the auction.
And they withdrew that.
That motion was
They
withdrawn.
withdrew it to move to vacate the default in housing court.
Correct. But each and every cause of action in this complaint, which was dismissed by Judge Bannon, has not been withdrawn. And each and every cause of action in this complaint seeking monetary damages arises from that judgment of default.
There was
So I
no,
just wanna
yeah,
So
go
I
ahead.
want to be clear, the only thing withdrawn was the motion for
Correct.
preliminary injunction, nothing
Correct.
else.
Correct, Your Honor.
And there was no stipulation of discontinuance of any claims or anything like that?
No, Your Honor.
Or even a motion to discontinue?
No.
Okay.
So, Your Honors, my only 2 points, one, which I think has been addressed by this court, which is, of course, just by the four corners of the pleading, each and every cause of action relates to the housing court judgment. This is, of course, a collateral attack. Anything outside of that are new facts and new arguments that are not in the record and are not before the court. If Your Honors have any further questions, that's it for me.
Thank you very much.
Thank you.
Just very briefly, in addition to the notice of sale challenge attack in Supreme Court, not being a collateral attack on civil court because the notice of sale was not at stake in civil court, we had our arguments on why that would be misapplication of the law to dismiss the money judgment claims, even insofar as relating to what happened in the housing court, which when I got into this case, I saw as egregious. That's all I want to say is that.
Thank you very much. Bunty versus Andrews.
Good afternoon, Your Honors. May it please the court, Ankit Kapoor for the appellant, Mr. Andrews. Your Honor, this is a case of first impression before this department because the lower court in this case created a marriage where there was no religious solemnization. It was in violation of New York case law. It was in violation.
Let me ask you a
of DRL.
question.
Yes.
You make a number of different arguments in your brief. I just want to understand, is your first and primary argument that this marriage could not have been a valid marriage under the domestic relations law, and that we are able to make that determination without getting into any determination of religious principles in order to make that determination?
Yes, Your Honor, and because the bishop unequivocally testified that he did not solemnize a marriage that day.
He did a blessing.
He did a Coptic 10-minute blessing. The lower court had no authority to turn that into a marriage. The court specifically recognizes it in NB versus FW case that the court cannot create a marriage where there is none. But here, that's exactly what the lower court did.
So you're arguing, just so I'm clear, that we can decide that there was not a solemnization under the domestic relations law without, just based on neutral principles of law, without getting into any issues about what is or is not a marriage under the Coptic religion.
As it relates to this, the religious marriage, yes, because you have unequivocal testimony by the two clergymen that were present that day, that we did not wed this couple on that day or on any other day. The inquiry stops there. The court cannot go into neutral principles once the bishop and the priest both say that they did not perform wedding prayers on that day. Because if the court then says, well, I am going to apply neutral principles, you're applying it to religious rites, R-I-T-E-S, and customs, which the court is not permitted to do.
So your secondary argument that making this determination would go beyond neutral principles of law is just an alternative argument if we don't accept your first argument that as a matter of law, there was no solemnization because you look at what happened then, it wasn't a solemnization.
Well, if you look at what happened, and also if you look at what happened thereafter, this is not like this.
Well, but that's my question, because the court looked at a lot of different things in reaching its determination. But it appears under the domestic relations law that there's no common law marriage in New York. So the only way there can be a marriage without a license is if there's a religious solemnization. So shouldn't the only thing the court really be looking at is whether on the day of the marriage, there was or was not religious solemnization in the manner heretofore used in practice in the respective society or denomination, which here is the Coptic Church. That should be our inquiry.
Yes, Your Honor, and the bishop unequivocally testified as to what is required, what are the uses and practices of this particular Coptic religion that were not met.
Can I ask you, did the parties, so Domestic Relations 12 says that the parties must solemnly declare in the presence of a clergyman, or let's assume it's anybody, and the attendant witnesses or witnesses that they take each other as spouses. Is there any evidence in the record that either party did that during this?
There is no such evidence, Your Honor.
And at least one witness besides the clergyman or whoever is doing the marriage must be present at the ceremony. Did anyone identify as a witness to the marriage?
Well, there was no witness in
Like
marriage because there was no marriage. But
okay, that's what I'm saying.
the parties
Did
were
someone
there
say,
for-
I'm witnessing these two people declare each other that they take each other as spouses?
Not a single witness in this trial testified to that effect, Your Honor. Even plaintiff respondent's own witness did not. The one witness that the court deems to be, quote, very credible, end quote, was...
Is that the person that appears via phone?
No, it's not a person that appears via phone. It's a witness, Mr. Goldberg, that the court deems to be very credible, who thought that this was a part of a Jewish ceremony, that they were walking around the church, which plaintiff's own expert clarified that walking around the church in that religion is for a baptism, not for a wedding.
Counsel, so it's clear here that under the Coptic faith that if the exchange of the rings is really what sets the vows, right?
According to the record, yes, Your Honor. That would be the exchange of vows, which there were none.
So let me ask you. So it's pretty clear that I think you're right in that no one says that there was an exchange of vows. There definitely was an exchange of rings. And I don't believe there's anything in the record that anyone says that there were oral vows that were said. Had there been oral vows, would your position change as to the court's ability to rule?
Had there been oral vows exchanged between the parties, Your Honor?
Yes.
And if there were oral vows and the bishop still came in and testified that that was not a completion of a Coptic wedding ceremony, then the court cannot go behind the bishop. The court has to accept the bishop's testimony. He is second to the Pope in that religion. For now, the court to create a marriage, it would be a violation of First Amendment and the separation of church and state, Your Honors. The court, and it's clear in Jones v. Wolf and the Serbian Orthodox versus Milijovic, where the court has to abide by the decision and determination of the highest ecclesiastical authority of a tribunal. Now, on that day, the bishop was the highest ecclesiastical authority in that church. The priest himself, who's a subordinate, stated that when the bishop is here, I take a second step. And the priest committed various errors. He testified, he admits that I was fairly ignorant as to what happened that day.
Thank you. We'll let you get into that in rebuttal if you want, but that's, yeah, thank you.
Good afternoon, Bonnie Rabin, Rabin Rent Partners for Lamia Funty.
I'm going to ask you a somewhat long question.
Yes.
There's no common law marriage in New York. That's undisputed. So the only way, in the absence of a license, to get married is if it's solemnized under domestic relations law, right? So that's the only question. Was it or was it not solemnized?
It was absolutely solemnized.
How? I'm looking at the decision below, and he really spends very little time on what is the cardinal question. Was there a solemnization? And it's very specific. Such marriage must be solemnized in the manner heretofore used and practiced in the respective Coptic
Correct.
religion. So that's the only question. So what evidence
I'm going to tell you
is there in this record that there was a solemnization in the Coptic Church, particularly where the bishop said there was not?
The bishop was not unequivocal. He was quite equivocal many, many times over many issues, including one of the most important issues in a Coptic marriage. That is the crowning ceremony.
But
there are no vows.
Everyone sort of agreed that there is always an exchange of rings in a Coptic marriage, which did not occur here.
Actually, the testimony was that over time, rings were part of the ceremony, but the most important part of the Coptic ceremony is the crowning, it's called a crowning ceremony, and because it was quote-unquote impromptu, because it was first the child's baptism, and then our client was baptized, that was unplanned, because
What
she
about the
couldn't be
fact
married.
that there was no exchange of ring? There were no vows, which of course is not.
There were
part-
no rings
Let me-
there.
Let me finish the
Yes, I'm
question.
sorry.
There was no marriage certificate or license, which is normal in a Coptic thing. There was no invocation over the parties to bless them and make them one, which is a tradition. None of the traditional indicia of what's required for a Coptic marriage was present at this
I don't agree, Your
ceremony.
Honor. I'm so sorry. I say that respectfully. The most important indicia was there, the crowning ceremony.
No, they didn't have crowns, right?
didn't have crowns, they had red
And the
ribbons.
bishop said what he did was not crowning. So how
He
do
did
you,
say it
how
was
did the,
crowning.
no, he absolutely said it wasn't.
If Your
He
Honor,
said
if you read,
that wasn't the crowning, that's the wedding crowning.
if
He
you
said
if you
that.
read the testimony, I'm so sorry, they didn't have crowns there.
And
The
he's,
only reason
exactly,
for him
but
to
no,
wear
no,
the
no, but
bornos-
that's not, he didn't say, if I had a crown,
Actually, he did.
he didn't testify, if I had this, I used this instead of a crown because I intended to have a marriage. He absolutely didn't say
Because
that.
it wasn't a planned marriage. It was an impromptu marriage, and there is no blessing.
Let me get, if we're going to be in a discussion about what is or is not a valid marriage under the Coptic Church, and we as a court are going to have to make that determination, don't we run into the wall of the second issue before the court, which is that we're not using neutral principles of law anymore. If the issue we have to decide this on or hang our hat on is whether or not the crowning and the ribbons are enough and all that stuff is enough, then aren't we going beyond using neutral principles of law, which we are not allowed to do?
No, Your Honor, I think it's exactly neutral principles of law. So, for example, the other cases in which you've addressed whether there was a ketubah, not everyone knows what a ketubah is, so there needs to be some.
But there's no dispute in the Jewish religion what the
Well,
significance
there was a
of
dispute.
ketubah
There was a dispute in one of the cases about whether it was improper to have a second ketubah in New York when there was a first ketubah in Florida. So I don't agree with Your Honor respectfully. I actually think if the court reads the record here, it's very clear that Father Gregory, who was there, who was the priest of this parish, after this ceremony, he prepared a marriage license.
never
But it was
signed by
never
anybody.
signed.
But he testified that they're often not signed because.
And he
people
said
don't
he
come
would
and
have to
get them.
defer to the bishop. But again, if we're getting into all those things, I think we're getting beyond neutral principles of law.
Your Honor, the most important neutral assessment of law is looking at what the facts are and the veracity of the witnesses, and that's exactly what Justice Hoffman did.
The problem is basically Justice Hoffman went into analysis of whether there was a common law marriage. He said, I'm not going to look at the solemnization, and he looked at things other than the solemnization.
No, I think he did.
to
I think
determine.
he looked at the crowning ceremony. I think he looked at the bornos. No one had any explanation. There are only two times when you wear a bornos. One is when you're being ordained to be a priest, and the second is when you are becoming a married person.
Okay, but then he's got to say, the judge has got to say, the bishop lied when the bishop said, I did not to perform a ceremony. That's
Not
the
only did
only
he
way to
say
get
he
it done.
didn't perform a ceremony, he said the steps that you have to take to perform a ceremony. For example, the pre-courses.
But that's why the court looked at and you look at the other cases, it doesn't have to be exactly every single, this was an impromptu marriage. It wasn't planned. It was, and the bishop
There's a
had
lot missing here, counsel.
I'm listening.
The pre-courses are missing, the solemnization, the I take you as husband, I take you as wife, the exchange of rings, the signature on the marriage certificate. A lot is missing here, and we have the bishop saying, I did not perform this wedding.
Your Honor, if I may, it's very clear from the expert testimony, there are no vows taken in a Coptic marriage. That's something.
Again, then you're asking us to choose whether the bishop is correct in interpreting the law, that the Coptic religion, or your expert is correct.
No, I'm
because
asking the
that
court-
is what the bishop
No, I'm not.
said
I'm asking
something-
the court to
One
look.
second, counsel.
I'm so sorry.
I know, it's an exciting issue, it's a very good issue, but I'm saying it is, if the expert absolutely said something different from the bishop, and that would require the court to choose one over the other, getting into, you know the religion better than you, and that we are not allowed to do.
I don't think you're being asked to do that. I think you're being asked to look at the most objective evidence. When is a Bornos used? That's what you learned from an expert.
You're
That's not
focusing
going
on
to
that
religious
over every
doctrine.
other issue against you. You're saying that's the sole determinative issue. Why does that trump every other indicia that no ceremony?
You have a crowning ceremony. You have a Bornos. You have a priest who actually drafts a marriage certificate because he believed there was marriage. You have a man
didn't have him
who have
sign.
subjective intent of both parties who held themselves out as married and did things such as file with this court papers as if he were
Thank you.
married.
That goes beyond the initial question, which is whether or not there was solemnization. But we're aware of all the other evidence.
And I would ask the court to look at the record deeply on the issue of solemnization because
We, of course, will.
because looking at the other cases, the cases make clear it doesn't have to be perfect, and there was a reason for its
No, thank you.
imperfection here
Thank you.
because of the impromptuness.
Your Honors, when
Counsel, the ceremony wasn't perfect, or the bishop says he didn't perform a wedding?
the bishop said he didn't perform a wedding, it's not like the Prasad case that Justice Hoffman cites where he says it doesn't have to be a perfect ceremony. In that case, there was no question that there was a religious Hindu solemnization. This is the first case where we have no solemnization. If you look at the Mataretti case from the Second Department, the defendant or the plaintiff testified that there was a alleged wedding under the Hindu religion in 1952, and the court stopped this. The appellate court reversed the lower court.
So what would have been needed here to show solemnization?
I'm sorry?
What would have been needed? What would have been satisfactory to show solemnization?
The bishop and or the priest stating as such that we wed
Wait a
this
minute.
couple today.
So if the witnesses go, so if the evidence was that the witnesses testified that there was no exchange of vows, that there was no exchange of rings, that there was no crowning, that there was no the garment that they wore, yet the priest says that there was a marriage, we're supposed to accept that just because the priest said it?
Well, you can't accept because the priest said it, because the bishop was the highest authority.
That seems to be what you're saying. You're saying almost like we're bound whatever the priest testifies to as to what happened. And don't we have a role to take an objective view as to what happened according to the evidence that the court finds credible?
Yes, and the court is not bound by the priest. The court is bound by the bishop and DRL 12 that says in the uses and practice heretofore. The word heretofore is very important, and the court cannot and should not go behind DRL 12 and the First Amendment. Otherwise, this court would be in the position of creating marriages where there are none, and also there would be a dichotomy between the First Department and the Second Department because of the Mataretti case as well as the Bernstein case. When the rabbi in the Bernstein case came in and testified that I could not have performed the wedding, the same thing happened here. The bishop says, I could not have performed the wedding because all of these requirements were not met. And with the point regarding impromptu, the bishop specifically said, I cannot do impromptu weddings. I have never done impromptu weddings. It is very clear. And your honors picked up on the word solemnize in the judge's decision, in Hoffman's decision. It doesn't appear until page 30 of 34, your honors.
Thank you very much. Any other questions? Thank you. Capitis versus Ragtime Gourmet.
May it please the court, Rob Malatak for plaintiff appellant. Your Honors, this appeal is very simple and straightforward.
Counsel, don't we have to follow the other Capitis case, which seems very similar to this Capitis case, where the court found that there were issues of fact?
Yeah, we actually do have to follow the other two cases. The first case, Your Honor, is the Strategic versus Steenbach. That was a case where this court, after reviewing the record, including an agreement that was spot on with the agreement before this court now, concluded that that agreement was not a usurious loan.
Well, counsel, the case that I'm referring to, which has the same namesake, is Capitis Servicing versus Point Blank. Why is that case, which involves the same company, not controlling where they did found there was an issue of fact?
Well, just for clarification, the decision that I just referred, Your Honor, to which is at 189 of the record. That was by strategic funding, which is also a capitis entity, so it is the same plaintiff party. In terms of your specific question regarding the point blank construction case, that case involved a motion to dismiss filed by the defendant. And the three factors, as we know, that are in play when analyzing this type of agreement is one, whether or not there's a indefiniteness in terms of a time limit to the repayment. Two, whether or not there's a reconciliation provision. And three, whether there's any bankruptcy-related recourse. Those factors are well-known and applied in every court throughout this state at this point. So with respect to the indefiniteness, this court found that that the agreement was indefinite, and that suggests it's a sale as opposed to a loan. So that's the first factor. And in our case, we've established that there's an indefiniteness in our agreement. Unfortunately,
What about the bankruptcy provision, which supports the argument that it's a loan?
right. So
Isn't there conflicting evidence that supports each side?
I'll just keep going. In your
Not going to respond to the bankruptcy issue, because really, that's it, right? That's where the document says the bankruptcy,
I
right?
apologize. I didn't mean to be short, because that was the next point that I was going to make.
I know, but you have to be flexible, right, oral arguments. So if I ask you a question, it's
You're right.
that you
I
respond
got a
to
little
it.
ahead of myself. I apologize. In terms of the bankruptcy, recourse, there, Your Honors found that that suggests that it's a loan. So in point blank, now we've got one factor, which is the finite versus indefinite issue, pointing towards it being an agreement. The second point is the bankruptcy issue, which points to it being a loan. So we're one for one, we're at a tie. In point blank, there was the third point, which the court looks for, whether or not there's a reconciliation provision. There, Your Honors found that there was a question of fact as to whether or not there was a reconciliation provision, because it was unclear. So Your Honors were not able to break the tie. Here,
Is that how it works? If it's 2 out of 3? I didn't realize that was the analysis. If it's 2 one way, then it's 1. If it's 2 one way, it's the other way?
it certainly seems the way that
Is that what our cases say?
that's the way they stack up. In fact, the
No, but or how about, wouldn't it be more accurate to say, so if there's evidence on both sides, we go to the trier of fact to see what the party's intent was? Like any other ambiguous agreement, right? We go and ask the trier of fact, based on all these factors, what was the party's intent when they entered into this agreement? Was it for a loan or was it for a sale? That's generally what we do when the agreements are ambiguous. So if we have some things here that show a loan, which is guaranteed repayment and bankruptcy provisions, and some things which show a sale, which are the things that you've rightfully pointed out. But then, under those circumstances, we say this ambiguous agreement has to go to a trier of fact to see what the party's intent was.
On those points, one, the agreement is not ambiguous with respect to the bankruptcy provision.
No, I agree, the provisions, but what the parties intended with that document is ambiguous because it could go either way. It's not a 2-to-1. It could go either way.
I would just conclude my argument in that the courts apply this particular factor very flexibly. There's numerous cases that I've cited in a brief where courts have said, well, you know, where you've met the indefiniteness requirement, where there's clear evidence of a reconciliation, we're going to, they don't turn a blind eye to, but they don't credit as much the existence of bankruptcy recourse in the face of meeting those other two factors when
Thank you.
factors support a sale agreement.
Thank you very much.
Good afternoon, Your Honors. Anthony Agrippina, may it please the court. Anthony Agrippina for the law officers, Anthony Agrippina for the respondents. Your Honors, as stated previously in my papers, summary judgment is by far premature at this juncture, and the lower court was absolutely correct. First and foremost, we lead to Jolie Holding Corp. The plaintiff or respondent, the petitioner, basically alleges that Jolie Holding Corp was duly served and is the party defendant to the action. Jolie Holding Corp was never a party to this action, as we set forth. They were never served. There is not an entity, as they have captioned in the onset of the action. It says Ragtime Gourmet Corp / Jolie Holding Corp. They're two separate entities, as we said.
Focus on the primary argument, which is.
Certainly, Your Honors. I
A loan or a
apologize.
sale of receivable?
Your Honor, it's our contention that this was absolutely a loan. Counsel's trying to basically mask it and say it's not. If it looks like a pig, it's a pig, excuse my French.
So then why would you sign a document that says, if you think it's a loan, why you sign a document that says, the parties intend that the transfer of the interest in the receipts from Ragtime to Core constitutes a sale and not a loan for all purposes? Why would you sign a document that says that if you don't think it's a sale?
Can I be quite honest with you?
Aren't you bound by your, yeah, you want the money, right?
Excuse me?
That's not, you
I'm
want
not
the
looking
money.
for the bond. No, Your Honor, I'm going to be quite frank. My client is a layperson who signed it. He runs a deli. I don't even believe, and I'm told it.
Yeah,
not-
but okay, but you can't.
I'm not using that as an argument, but I'm saying is, I don't believe, he's going by what was conveyed to him by the individual representative, the lending officer who lent him the money. First and foremost, the payment, it's not a contingency. The payment is absolute here. Because it is absolute, it makes it on its face a loan. Right? There is no right for reconciliation. The borrower, meaning the respondent, did not have the opportunity to say, okay, things are bad, let's reconcile, let's come through. It was 8% every day, each and every day. There was no opportunity for reconciliation. Therefore, that makes it a loan on its face. Bear with me one moment. And if deemed to be a loan, it's on its face a usurious loan at a minimum. The bankruptcy provision, as the court addressed, the loan document clearly set forth any and all of their rights and remedies, including bankruptcy provision, assignment of a lease, assignment of assets, assignment of personal goods. That is everything you would find in a loan document.
Right, but there are certainly other evidence. There is certainly other evidence, including your client's statement that I intend that this be a purchase and sale, that indicates that it's a purchase and sale, right?
No, Your Honor, it was my client's belief that this was a loan.
Well, you signed a document that said that, correct? And I get your
You
client's
signed, Your Honor,
a
I'm not going to
layperson,
dispute.
wants
My
the money,
client
but
did
that
sign the
doesn't.
document.
1 second, let me
I
just finish
apologize.
the sentence. But that doesn't relieve him of the obligation of what he says in the agreement. So the agreement is quite ambiguous because you're right, it does have bankruptcy provision and it does have a guarantee, but it's also indefinite. It's only up to it only has a certain number percentage, and your client says it's a sale in the document. So it's very unclear one way or the other whether it's one or the other.
Your Honor, respectfully, it is hazy, and that's why I say, at this point, a summary judgment would definitely be premature. We're entitled to discovery. We're entitled to move forward. We had a preliminary conference, and that was it. And the next thing, the plaintiff moved for summary judgment, which we believe correctly the lower court denied and basically said to move forward, and that brought us here today. We're not asking for a miracle. We're merely asking to go back down to the lower court, allow us our opportunity for discovery to determine whether or not this is in fact a loan or whether it is a purchase of assets, which we do not believe it is. To basically take away the client's right would be irreparable harm to him.
Thank you.
Thank you so much, Your Honors.
Just briefly, there are no shortage of cases applying the factors out of the Olaf case in the Second Department. Here, we've clearly satisfied the first two, which is the finiteness the lack of finite and also the existence of a reconciliation. The reconciliation is automatic. Here, we were only entitled to take 8% of the daily cash receipts. That's unlike other agreements where you've got a fixed payment amount and you have to true up to the actual receipts. So we have the first two. The other, the bankruptcy-related prong is applied, that one is applied most flexibly by every case that I've read.
Well, where do you get a guarantee in a purchase and sale? If I buy chicken legs, nobody's guaranteeing payment of the chicken legs, right?
Understood, but just added protections and just.
You're saying to me that there's nothing that would show that this is a loan, and I think there are plenty of things that could show that it's a loan. That's all I'm saying.
Understood, Your Honor. A guarantee, though, is not uncommon in these type of agreements, and it's very common for decisions by.
Yeah, in a factoring situation, sure, but not in a purchase and sale.
Thank you.
Thank you.
382 McDonald.
Good afternoon, Your Honors. Lee Lefkowitz from Zarin and Steinmetz for the appellant. May it please the court. There were a number of errors by the respondent, IDA, as well as the lower court, that in sum deprived my client of its right to be heard and actually reached the substantively wrong result with respect to the.
Address the standing issue first, since that has to be resolved before anything having to do with the merits is resolved, and why there is standing in this case.
Sure, Your Honor. So the cases that we've cited deal explicitly with economic statutes, and we're dealing with an economic statute here. This is the fresh law, and it deals explicitly with trying to balance the competitive landscape of supermarkets in food deserts. We are a supermarket that is less than a third of a mile from the supermarket that was granted these fresh benefits.
Are you disagreeing that the cases seem to hold that competitive injury in and of itself is not enough to confer standing to challenge an administrative determination? Are you saying it is enough within it, in and of itself?
So I'm saying two things, Your Honor. One is it is enough.
What about the Hunt case?
So the Dairy Lee case, I think, is the most important case here. In that case, there is a line that says ordinarily an economic injury isn't enough, but we look to the statute to see what type of a statute is it. In that case, Your Honor, we were dealing with a milk supplier who was granted a license to sell milk that competed with the plaintiff in that case who wanted to challenge the grant of that license. That was the only basis he had to challenge it, very similar to here.
What's your basis for arguing that this particular statute primary purpose or objective is to prevent destructive competition as opposed to helping out a neighborhood generally?
So just to close the loop on the Dairy Lee issue, there we're talking about a milk supplier whose license is being challenged by a competitor, and the court said you have standing even though it's an economic issue. Here, to answer Your Honor's question, the fresh statute was designed to facilitate and encourage the development of supermarkets in places where there were food deserts. The reason for this statute is that to balance the competitive landscape. There are certain areas of the city that it's not profitable for purveyors of supermarkets to establish supermarkets. So they established a statute to give tax breaks to them because there wouldn't be competition in those areas. It's okay, the legislature said, to give those purveyors a little bit of a leg up in areas where there wouldn't be competition, and that's what the statute does. Here, the respondent was given this leg up despite that there's a swath of supermarkets in this area. So because this statute is specifically designed to balance the competitive landscape in supermarkets, it follows that a neighboring supermarket that's going to be affected by the grant of benefits and given this competitive advantage to one supermarket over all the others should have standing to challenge it. Your Honors, what this statute did was actually the opposite of what Fresh intended. It's creating a market imbalance.
Other than economic damages or the lack of, you're saying, sort of reducing or increasing economic competition. Do you have any other damages?
So yes, Your Honor, and actually, I'm glad that Your Honor reminded me of that because it follows back to the original question because you asked me if all I have is economic damages. And the answer is no. We also, a big reason that my client opposed the fresh application or tried to but was deprived of the ability to was the fact that this establishment in a supermarket is going to create a traffic nightmare in this area. So
And did you put in a study from somebody to show
we
that?
certainly did, Your Honor. It's in the record. We submitted a traffic study that was unrebutted by the applicant that we're not even sure the idea even looked at because we never had a public hearing in front of the idea.
But is your harm different than anybody else's in the neighborhoods?
So,
as
Your
to
Honor, there's a
that?
lot of cases that deal with that and that proximity.
Okay, so the answer, so the question is your harm different than anybody else? The dry cleaner next door, whoever else, you know, the CVS down the block, is your harm any different from their harm?
Yes, Your Honor, for two reasons. One is that going back to the fresh statute itself, we are a supermarket.
No, no,
So-
no, no, no.
so
You're
that's
talking
different.
about traffic.
And then
Traffic.
talking about
Your
traffic.
traffic is more, why does the traffic nightmare harm you more than CVS and the dry cleaner too?
Because we are, as detailed in that traffic study and in our brief, supermarkets require a tremendous amount of truck trips, up to 100 a week. So we
And
have,
CVS doesn't?
They don't,
And
no.
all the other stores in the neighborhood don't?
no, Your Honor, they don't because they're not bringing in perishable items. Supermarkets require their items to be replaced daily, fresh fruits and vegetables. So we're doing 100 truck trips a week. A big reason that we oppose this is that the last use on this site was a pharmacy, Your Honor, and there weren't this kind of traffic based on that pharmacy. A supermarket will bring tremendous amounts of more traffic that will directly impact my client and other supermarkets in the area who are also trying to get trucks through these narrow streets and that are double parked on these streets with two elementary schools nearby with kids trying to walk to and from school. And so the traffic issue is unique to my client in addition.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honor. May it please the court, Rebecca Viscatas for the New York City Industrial Development Agency and Economic Development Corporation.
I want to know, did the petitioner put in any studies to show the impact that the traffic would have specifically on them?
No, Your Honor. The engineering review that petitioner submitted advocated for an in-depth traffic study that would examine the question of what effects the supermarket would have on the neighborhood, but it certainly did not discuss any specific effect on petitioner, and it didn't make any conclusions about whether there would actually be an increase in the levels of traffic compared to what was already there from the large.
That's what I was going to ask, because it was a pharmacy before, which I imagine, because people are getting their drugs every day, their prescriptions every day, must have had a ton of traffic. Is there anything that the petitioner submitted that would show that that traffic was any different than a truck coming in and bringing, you know, cheese doodles?
No, Your Honor. This is purely speculation from petitioner, and the study that they submitted did not make any comparative judgment about that.
Can you talk about Derry Lee and about the standing issue for a moment, please?
Sure. Derry Lee addressed a statute that was specifically about licensing for milk plants and directed that those licenses should be denied if they would lead to destructive competition. And what the court in Derry Lee said was that that very specific reference to preventing destructive competition showed a legislative intent that was very narrowly designed for that purpose. Here, petitioner keeps referring to the FRESH law, but the FRESH program that the benefits here were awarded under is a program that is administered pursuant to the general municipal law, and the provisions of that statute, which petitioner in their brief do cite, only use very general language about industrial development agencies' power to provide financial assistance with the goal of advancing job opportunities, health, general prosperity, economic welfare. And IDAs are instructed to establish uniform tax exemption policies that consider 11 different criteria, just one of which is the impact of a proposed project on existing and proposed businesses in the vicinity.
So is it your position that the only damages that the petitioner is alleging are economic loss damages, which would then not confer upon it standing?
That's correct, Your Honor. That the only injury, they do assert the environmental injury regarding the traffic, but
But that's to everybody, right? Anybody in the neighborhood. There's nothing special about one store as opposed to another with
right,
respect
and
to.
they even assert that the real parties in interest are the school children who will have a hard time walking to school.
They don't represent the school children,
Exactly.
right? Okay.
But regarding their primary claim about the threat of increased competition from a new supermarket, that is exactly the kind of non-cognizable injury that courts have recognized is not enough for standing.
And don't we want to encourage competition?
That's certainly what several of the IDA board members here felt, and I think that there is a legitimate policy argument for that, this is not a program, petitioner refers repeatedly to food deserts, which is not something that is a specific consideration in this program. There's a separate zoning incentive program that has slightly different eligibility requirements, but this tax incentive program is designed to increase options, and it's very possible that increased competition could actually be a good thing for neighborhood residents to ensure that they are not being overcharged for fresh produce in their neighborhood, especially since this is a program that is designed to benefit residents of historically distressed neighborhoods.
Thank you.
Thank you, Your Honor.
May it please the court, Richard Lobel, Sheldon Lobel PC, representing the non-municipal respondents 302 Mead Corp. And 306 Church Realty Corp. I echo the arguments of the municipal respondents, particularly with regards to the standing issue. The harms that were alleged were merely competitive harms. Moreover, the impact analysis, and I think it's important to note, we're dealing with an agency with some expertise, one that hears these cases, the IDA hears these cases on a regular basis. And so there's a reason why the court is instructed to defer to this agency expertise. And so when looking at the record as a whole, merely something as the allegation of competitive harm, there was a 2-page or less than 2-page report with a 1.5 pages summarizing the economic harm to appellants, and it just basically made allegations as to the percentage of business that would be lost basically as a result of this fresh application. Whereas there were studies that were performed, nonpartisan studies by the IDA, by the EDC, their staff, which demonstrated in actuality that those allegations were not based on real numbers and that the actual competitive harm was degrees less than was alleged by appellants. So, again, to the extent there's other questions, we're happy to answer them, but we would summarize our arguments in that respect.
Thank you.
Thank you.
I'll try to get through a few points very quickly. The traffic study is on page 79 of the record. It's not quite what I think the IDA Council characterized it as. It's an in-depth traffic study that actually analyzes pedestrian traffic and truck traffic in the area, as well as truck turning radiuses on these narrow streets. That's different than what counsel indicated of the economic impact analysis. That's a separate analysis that my client provided to the EDC, which separately showed the impact on my client's economics, namely that they lose 30% of their business as a
Does the traffic study show the specific impact that it would have on your client?
It shows the impact of the 2 or 3 block radius, which is where my client is. So it's not common for a traffic study like this to say, here, this is the impact on this particular food town. It's looking at the entire area. So that's what it does what it's asked to do. Your Honor,
So then how are you proving that your harm is different from anybody else in the 2-block area?
Your Honor, when we get approval to establish our supermarket there, we're required to show that the traffic works, that our truck trips work, and that it can fit in this tiny area. So we are differently situated. We're relying on the traffic pattern in the area working. So, but Your Honor, I don't want to lose sight of the economic issue. This is an economic statute. Your Honor asked, don't we want to encourage competition? Of course we do. This is an as-of-right use. This supermarket, we have no question that they can build a supermarket here. The question is, should they be given a tax advantage over all the other supermarkets? This isn't encouraging competition. Let them build their supermarket. Don't give them a leg up in terms of their annual taxes of up to $128,000 every year to over to the disadvantage of all the other supermarkets in the area.
Thank you.
Thank you, Your Honor.
Thank you very much. Our last case of the day, Lovett versus 2600 7th Avenue. Your turn to argue.
I have a question. Before my time begins, I have requested 15. And I didn't.
I'm sorry, what?
Before, I have requested 15 minutes, and I didn't understand when you was asking.
No, but nobody gets the time they request, though. Everybody, as you noticed, probably listening to the calendar, everybody gets less time than what they requested. 15 is the maximum we could give. No one ever gets 15. So you got a time.
I timed
Your
myself.
time, you have to start arguing because your time's going to start running, but no one gets the 15 minutes. We always give less time, or else we'd be here till 8 in the evening, which we're not going to be, so. But go ahead. If we have more questions, we'll keep asking them.
My name is Charles. I am the plaintiff appellant representing myself. I am respectfully requesting that the court reverse the lower court's decision dismissing my claim. My case arises from a series of events that happened at my apartment building that I rent. And so that's what I'm saying. I'm nervous.
It's okay. I just want to reassure you that we've carefully read all the papers, all the briefs, all the records. So we're all very familiar with everything, which is why you might not need as much time as you think, because we're familiar with everything. But we understand you're nervous, so just go ahead and present your arguments.
I believe that the court erred in dismissing my premise liability and the foreseeability claim because I had alleged that Mr. Davis, the defendants knew that there was an issue with him and they did nothing about it. And so then when I brought my accusations, they were already aware of prior things that had happened in the apartment, in the building with him. So that was the foreseeable that they would have known and should have addressed.
Were they because we saw, I saw in the papers that he had an issue with alcohol and that he had acted inappropriately in the past. What does inappropriately mean?
I was just told from the apartment manager that there were prior complaints on him.
Yeah, but what were these complaints about? Were they sex-related? Did he assault somebody? What did he do?
That's what I don't know. I just know that when I brought my complaints, I was told that there was prior history. I didn't go into details because, that wasn't what I was asking. I was just letting her know what had happened to me, and she had advised that they were aware that he had prior complaints. There had been prior times where he was in the building appearing inebriated. So again, they were aware that there were issues in terms of him being, so that's where the whole foreseeability came into play. As it relates to my second count, I believe that, again, the ongoing exposure that was caused by the issue that he had happened and then him continuing to be in the building, that's what caused the emotional distress and ongoing harm. With respect to the statute of limitations, it is my claim that what happened was not frozen in time. And so there shouldn't have been a statute of limitation when it was still ongoing as he was there. And
Well, are you, wait. When you're saying that you had a terrible, terrible thing happen to you, and you came and some photographs were taken of you, right? And that's what you're claiming was right. So how are you saying that that's continuing?
because people are still coming up to me acknowledging that it happened. And so if I have someone still in 2025 coming to me saying that, oh, I remember seeing the video that was shown, how does that not show that it's an ongoing situation?
Did they show the video again after that first time that they showed it?
I'm not for sure. I just know.
Did any of those people that came up to you say, oh, you know, last week we saw this video of you?
No, sir.
No, they didn't. They say that they saw it once.
Yes, sir.
When it was first shown. Okay.
I guess that's it.
Okay, you're going to get a minute in rebuttal after he argues if you wish, okay?
Good afternoon, Your Honors. May it please the court. Alex Litt on behalf of respondents. I just want to.
Counsel, on the issue of foreseeability, other tenants allegedly complained that the porter was intoxicated and exhibited inappropriate behavior. What was that inappropriate behavior?
I mean, candidly, I have no understanding of that. All I know is what's alleged in the complaint. And
So if you don't know what that behavior was, how can you possibly argue that what happened to plaintiff was not foreseeable?
well, because general or a vague allegation of inappropriate behavior is not sufficient to foresee sexual misconduct.
But nobody knows what the inappropriate behavior was, not you, not us, not him.
Well, that may be true, but at this point, what's alleged in the complaint, I mean, a vague, inappropriate behavior wouldn't be sufficient because case law holds that for premises liability for a sexual, for a criminal activity, there has to be specific allegations or specific foreseeability of what that specific crime is. General inappropriate behavior wouldn't be specific enough here.
So since we don't know what it is, then we just have to take your word on it, correct?
Well, we take the allegation and give him all favorable inferences, but I don't think that would still be, even giving him all favorable inferences, sufficient to foresee the criminal conduct that allegedly occurred here.
I'm just curious, because Melissa Pagan told him several tenants had complained, and I just wanted to know what the inappropriateness was, but you don't know it, so thank you.
It's not in the record, it would be beyond the scope here, but yeah, I don't think at this point that is sufficient to allege that it was foreseeable that there would be a sexual harassment or assault at this, that would be sufficient for a premises liability claim. And then similarly, I guess intoxication alone also wouldn't foresee any kind of sexual criminal activity or criminal assault. So unless there are any other questions, I'm happy to wait my time.
Thank you. So you have a minute for rebuttal if you wish.
So I guess just with respect to that, because the lower court didn't even give it time to get to that stage to weed out what those other issues were, that again goes back to why the case shouldn't have been dismissed so early, because there wasn't the information known of what had happened. There was foreseeability because of the fact that there was prior issues with the employee as a whole that the management acknowledged. And so that is why it's just, this is not just about, to me, this is about the fundamental rights of myself being safe in my own home. I'm taunted outside because of how I am. The one place I should feel safe is in my own home, which did not happen in this case.
Thank you.